So, I want you to think about a little piece of plastic. It is probably sitting in your wallet or your purse right now.
Oh, yeah.
It's, maybe 3 inches wide, couple inches tall, usually has a highly unflattering photo of you printed on it.
The driver's license?
Right, the driver's license. We just treat it as this completely mundane administrative thing. You need it to buy a bottle of wine or to get on an airplane or obviously to drive a car.
That's just background noise in our daily life.
Exactly. But today, we are doing a deep dive into how that specific little card, and more importantly, who happens to be physically holding it, can become the entire fulcrum for a massive federal legal battle.
It is wild how that works.
It really is. We are going to look at a situation where the difference between basically walking away free and facing potentially a decade in federal prison came down entirely to who was holding that piece of plastic for a matter of, seconds.
And that is what is so genuinely fascinating about constitutional law. I mean, we have these grand, sweeping rights written centuries ago, right? The Fourth Amendment. And yet they constantly crash into the modern world in the tiniest, most highly specific physical actions.
Yeah, we aren't talking about a high-speed chase today.
No gunfights, no kicking down doors.
Yeah.
We are literally talking about a moment of hesitation in a parking lot and a police officer's memory lapse. That is the entire battlefield here.
So the source material we are diving into today is an analysis of a case called United States v. Carl Jordan. And we are looking at this through a breakdown provided by attorney Anton Belton.
Right, from the Wastash Law Firm.
Which is just incredible branding, by the way. I love the name.
It is very memorable. But more importantly, we really need to pause on his context for a second to understand why his analysis carries so much weight. He is based in the Southern District of California, specifically San Diego.
Okay, so a border district.
Not just a border district, but one of the absolute busiest federal jurisdictions in the entire United States. I mean, Belton is dealing with high-stakes federal criminal defense day in and day out.
So he's seeing a lot of narcotics, firearms, massive immigration cases.
Exactly. When an attorney from that specific district breaks down a search and seizure case, they aren't just giving you abstract law school theory. They're speaking directly from the trenches. They watch the Fourth Amendment get tested in real time every single day.
So we have a highly credible guide for this, and our mission for today's deep dive is to unpack this specific situation with Carl Jordan, but we're really using his, let's call it a very bad day, to understand 3 massive legal concepts that Belton lays out.
Right, we have a clear roadmap.
Yeah, first we need to figure out what the show of authority doctrine actually is. Then we need to understand this concept of tainted consent, which honestly sounds like a 1980s heavy metal band.
It really does.
But it's actually a massive legal lifesaver. And finally, we're going to look at the exact test the Supreme Court uses to decide if you are legally free to go, or if you are, for all practical purposes, a prisoner just standing out in the open air.
And I think what listeners will find surprising is that the distinction between I am free and I am a prisoner is almost never black and white. It is a highly nuanced spectrum. And in this specific case, the needle moves from one side to the other based on incredibly subtle police conduct.
All right, let's get into the facts. Let's set the scene based on Belton's breakdown. We aren't in a house. We aren't pulled over on the side of a highway. Where does this whole drama actually kick off?
We are at a bus stop.
A bus stop.
Yeah, it's a transition point. And the key actors here are 4 police officers. But, and this is a huge factor for the legal analysis later on, they are not in uniform. They are plainclothes officers.
So they just look like regular guys. Polo shirts, maybe jacket.
Exactly. No badges prominently displayed on their chests. No squad cars with flashing lights. And they're there conducting what law enforcement calls a drug interdiction.
Drug interdiction. See, that phrase always sounds so military to me, like they're intercepting a submarine or something. What does that actually mean in a civilian domestic context?
Simply put, it means they are proactively out there looking for trouble. They aren't responding to a 911 call about a crime in progress.
They aren't chasing a suspect who just robbed a bank down the street.
Right. They're standing at a transportation hub, a bus station in this case, and they are just watching people get off the arriving buses. They are looking for specific behaviors or characteristics that match a known profile of narcotics trafficking.
They're essentially fishing.
They're absolutely fishing. And out of this sea of people, they spot our protagonist, Mr. Carl Jordan.
Okay, so Jordan steps off the bus. Does the source material indicate he was doing anything wild? Like, did he look like a cartoon smuggler carrying a giant duffel bag with a $sign on it?
No, not at all. In fact, Belton specifically notes that Jordan is carrying only a small tote, just one single, relatively small bag.
So he's traveling incredibly light.
Right. And the record doesn't mention him acting overtly suspicious either. He doesn't bolt when he sees the cops, mostly because they're in plainclothes anyway. He just gets off the bus, walks out of the terminal area, and heads straight into the parking lot.
He's just trying to get home or wherever he's going.
Yeah, and he actually meets up with another individual in the parking lot. It looks to the officers like he is about to get into a car and leave the area. He is literally transitioning from the public transport leg of his journey to a private vehicle.
Mind his own business, about to leave the scene completely.
He is trying to, but this is exactly where the interdiction strategy kicks in. The officers decide, right at that moment, to approach him.
Okay, put yourself in Jordan's shoes for a second. You are in a parking lot. You are just about to hop into your buddy's car, and suddenly 4 adult men walk up and surround you.
Even if they don't have uniforms on, that is an inherently intimidating moment. People know when they are being approached by authority figures. Cops carry themselves in a certain way.
Yeah, it's definitely a tense situation.
Absolutely. And from this precise moment forward, the exact sequence of events becomes the entire ball game for the court. Belton breaks this interaction down step by step, and we really have to follow that sequence because the legal argument turns entirely on the order of operations here.
All right, let's walk through the play-by-play. What is step 1 of this encounter?
Step 1 is the approach. An officer walks up to Jordan and asks him a very simple, seemingly harmless question. He asks, "Are you willing to talk?"
Ah, the friendly opener. It's the classic, hey buddy, got a second maneuver.
Exactly. And legally speaking, this is incredibly dangerous territory for a citizen, but Jordan decides to play along. He says yes.
Okay, so he has engaged with them. He didn't just ignore them or tell them to get lost. He opted in. So what is step 2?
Step 2 is where the paperwork comes in. The officer asks Jordan for his driver's license and his bus ticket.
They want to know who he is and where he just came from. And Jordan complies.
He does. He voluntarily hands his physical identification and his bus ticket over to the plainclothes officer.
All right, so now the cop is holding his documents. Step 3.
Now that the officer has the documents secured in his hand, the tone shifts. He escalates the conversation immediately. He asks Jordan directly, "Do you have any narcotics?"
Okay, so subtlety is completely out the window at this point.
Completely out the window. They drop the pretext, and Jordan answers no.
Which, spoiler alert for later in the story, is a pretty massive lie.
A very significant lie, yes. But that brings us to step 4, and this is the exact moment that makes every single defense attorney out there just cringe in physical pain.
Let me guess. They want to look in the bag.
You got it. The officer asks if it would be okay to search that small tote bag that Jordan has been carrying.
And Jordan, who we now know definitely has drugs in that bag, says what?
He says yes. He verbally consents to the search.
I really have to pause the legal analysis right here. I don't get it. Why do people do this? He knows he is going to get caught the second they open the zipper. Why on earth would you give them permission?
It is so common, and it is a fascinating psychological phenomenon, even more than a legal one. When people are cornered by authority figures, they often think that if they act extremely cooperative, the officer will somehow trust them and just let them go.
Like a Jedi mind trick. I'm so cooperative, you don't even need to look.
Essentially, yes. They think if I say no to the search, I immediately look guilty. But if I say yes with a smile, maybe he won't actually bother to look, or maybe he'll just quickly glance and miss the contraband. It is a massive gamble born entirely out of panic.
And in Carl Jordan's case, it was a catastrophically bad gamble.
Terrible. Because, of course, the officer actually searches the bag. And inside that small tote, he finds over 50 grams of cocaine, plus a small amount of marijuana.
Over 50 grams of cocaine. I mean, that is not a casual personal use amount.
Not at all. That is a trafficking amount. The moment they find that, Jordan is immediately looking at heavy federal charges under 21 U.S.C. 841.
Possession with intent to distribute.
Exactly. We are talking about the potential for many years in federal prison.
And Anton Belton, the attorney whose analysis we are looking at, he actually completely stops his legal breakdown right at this point in the source material just to give some blunt life advice, doesn't he?
He does. It's like he virtually reaches through the screen and grabs the viewer by the shoulders. He says it so explicitly. Never consent to searches. It never helps.
It really is the golden rule of criminal defense.
It absolutely is. And Belton's point is incredibly pragmatic. Look, if you actually have nothing to hide, Consenting to a search is just wasting your time and letting the government unnecessarily invade your privacy on the side of the road.
Right, there's no upside for you.
None. But if you do have something to hide, like Jordan did, consenting is basically signing your own conviction paperwork right there in the parking lot. You are voluntarily waiving your Fourth Amendment rights. You are handing the prosecution the physical evidence they need on a silver platter.
Which brings us to the trial phase. Because on the surface, looking at these 4 steps, this looks like an absolute slam dunk for the government. Jordan said he was willing to talk. He handed over his ID. He said yes to the search. They found the coke. Case closed, right? Pack it up.
That is exactly the narrative the prosecution brings to the court. They look at this sequence of events, and they just see a perfectly standard consent search.
Because consent overrides the need for a warrant.
Exactly. Consent is a very well-established, very common exception to the Fourth Amendment's warrant requirement. If I ask to come into your living room and you say, sure, come on in, I don't need to go find a judge to sign a warrant. I have your explicit permission.
So the prosecutor's just pointing at the transcript going, look, Your Honor, he said yes. How does a defense attorney even begin to fight that?
This is where we get into the core conflict of the entire deep dive. The defense doesn't deny that he said the word yes. Instead, they argue that his consent was legally tainted.
Tainted consent. Okay, break that concept down for us.
It is deeply tied to a famous legal concept called the fruit of the poisonous tree doctrine. The defense's argument is that Carl Jordan was actually already legally seized by those officers before he ever uttered the word yes to the search.
Okay, so we are establishing a very specific timeline here. The defense is saying illegal seizure happened first, and then the consent happens second.
You nailed it. That order is everything. If the police are holding you illegally, meaning they have seized you without any reasonable suspicion or a probable cause, then anything they extract from you during that illegal holding period is contaminated.
It's the fruit of a poisonous tree.
Exactly. It becomes completely inadmissible in court. It literally does not matter if you enthusiastically said, yes, please search my bag. If you were being detained illegally at the exact moment you said it, the law says that yes doesn't count. It is void.
Wow. So to win this, the defense has to successfully prove to a judge that Jordan was officially seized at some point before step 4, before he agreed to the bag check.
Right. And where does the defense plant their flag? They argue the seizure wasn't when the 4 guys walked up to him. It wasn't when they asked him if he wanted to chat.
So when was it?
The precise moment of seizure, they argue, was when Jordan handed over his driver's license and the police officer did not hand it back.
The theory being, you have my identification card, therefore I am trapped here. I am not free to go.
Precisely. The entire weight of this federal drug trafficking case comes resting on the legal mechanics of that one specific handover of a plastic card.
Okay, this forces us to get really, really granular about what the word seizure actually means in a courtroom. Because I think if you go ask a random person on the street to define a police seizure, they are going to picture something violent, someone being tackled to the concrete, thrown into handcuffs, or shoved in the back of a squad car.
And they wouldn't be wrong. That is definitely one type of seizure. The Fourth Amendment protects us against unreasonable seizures of both our property and our persons. Belton breaks the seizure of a person down into 2 very distinct categories.
Okay.
The first category is exactly what you just described, physical force.
The tackling scenario.
Right, the tackling, an officer grabbing your wrist, physically locking your path with their body so you can't walk past them. If a law enforcement officer physically lays hands on you to restrict your freedom of movement, congratulations, you have been seized. That's the easy, straightforward category.
But looking back at the facts Belton gave us, nobody tackled Jordan.
No, they were plainclothes officers. The official record doesn't show that they ever drew their weapons. They didn't grab his arm. They didn't put him in a headlock. So the physical force category is totally off the table.
Which means we are operating in the second, much more slippery category?
Yes, we are in the realm of the show of authority.
Show of authority. See, that phrase sounds incredibly vague. How do you even measure that?
It is famously vague, and it is the subject of endless, brutal litigation in appellate courts all over the country. Broadly speaking, a show of authority means the police have behaved in a way that essentially restrains your liberty, even though they haven't laid a single finger on you.
So it's more of a mental trap than a physical one.
Exactly. They have created a psychological barrier, or a situational barrier, that effectively prevents you from leaving the encounter.
But how does a judge actually decide if a show of authority has occurred? Like, is it just based on whether Carl Jordan personally felt really scared in that moment?
This is a critical distinction that Belton points out. It is not about whether the specific defendant felt scared. And interestingly, it is also not about what the police officer secretly intended to do in their own head.
Okay, so it's not the cop's intent and it's not the suspect's actual fear. What is it?
The Supreme Court settled this in a massive landmark case called United States v. Mendenhall. In that case, Justice Stewart established what we call an objective test.
An objective test, meaning they use a standard ruler to measure the situation rather than asking the people involved.
Correct. Instead of diving into the messy psychology of the specific people on the scene, the court uses a hypothetical standard. The Mendenhall test asks, in view of all the circumstances surrounding the incident, would a reasonable person have believed that he was not free to leave?
The reasonable person.
Yep.
The law absolutely loves that guy.
The reasonable person is the ultimate protagonist of the entire American legal system. It's a completely hypothetical construct. The judge basically has to sit back and say, okay, let's imagine a totally regular, average, law-abiding citizen standing in this exact parking lot. If they were in this situation, would that person feel like they could just say, no thanks, turn around and casually walk away from these officers?
And if the judge decides, no, a regular person would definitely feel forced to stay put, then the court rules that a seizure has happened.
You've got it. And to make this slightly less abstract, Belton's analysis breaks this Mendenhall standard down into a very specific three-pronged test. This is basically the mental checklist the judge has to walk through.
All right, let's go through these prongs. Let's build the checklist. What is prong one?
Prong one is exactly what we just discussed, the reasonable person standard itself. Would a reasonable person in that specific moment feel they could not disregard the police inquiries and just go about their business?
Okay, so establishing the baseline feeling of being trapped. What is prong two?
Prong two focuses on the actual cause of that trapped feeling. The legal restraint must be the result of the police conduct itself,
As opposed to what?
as opposed to just the general environment. Belton uses the bus stop setting as a perfect example of this.
Okay, break that down.
Think about being inside a busy bus terminal. It might be incredibly cramped. It might be physically enclosed. There might be a huge crowd of people pressing in on you. You might literally feel hemmed in and unable to easily walk away.
Sure, just because of the architecture and the crowd.
Right. But that feeling of being trapped doesn't mean the police have seized you. To satisfy prong two, the police officers have to be the ones actively creating the coercive pressure.
So if I accidentally wander into a dead-end alley and realize I can't go forward, that's my own problem. But if I'm in that alley and two cops suddenly stand at the entrance and stare at me, that is police conduct creating the restraint.
Exactly right. The constraint on your freedom has to emanate from the badge, or, in Jordan's case, from the plainclothes officers acting with the authority of the badge. It cannot just be the happenstance of where the conversation is taking place.
That makes perfect sense. All right, what is prong three?
Prong three is the one that really trips up a lot of law students, to be honest. It is known as the subjective component, or the requirement of submission.
Submission.
Yes. For a show of authority seizure to legally exist on paper, the citizen must actually submit to that show of authority.
Wait, I need you to unpack that. Are you saying that if the police try to seize me, but I just completely ignore them, I haven't legally been seized yet?
That is exactly what I'm saying. And this rule comes from another very famous Supreme Court case called California v. Hodari D.
Okay, tell me about Hodari D.
Imagine a police officer is chasing a suspect down the street, and the officer yells, "Stop! Police, don't move."
Okay, that is an incredibly clear show of authority. He is ordering you to stop.
It is the ultimate show of authority. But under Hodari D, if you look back at that officer, ignore his command and keep sprinting away. If you do not yield to his authority, then legally speaking, you are not seized.
That is wild.
It is. In a show of authority scenario, the seizure does not technically begin when the officer gives the order. It only begins the moment you obey the order and stop fleeing. Until you submit or until they physically tackle you to the ground, no seizure has occurred under the Fourth Amendment.
That feels almost counterintuitive, but I get the mechanical logic of it. The authority has to actually take effect on you for it to count. So, taking that back to our guy Carl Jordan in the parking lot. Did he run away?
He did not. He stood right there. He answered their questions. He reached into his pocket and handed over his identification. He fully submitted to the interaction. So prong three is definitely satisfied.
Okay, so let's review the checklist. We have submission, because he stayed. We have police conduct, because they approached him and asked for his papers. So this entire federal case really just boils down to prong one.
Exactly. It all comes back to, would a hypothetical reasonable person standing in that specific parking lot, having just handed their driver's license to an officer, feel totally free to just walk away.
And this brings us directly to the core of Belton's analysis, what we can call the driver's license nuance. This is where the rubber really meets the road in this
It
case.
really is.
Now, Belton is very careful to point out that simply asking to see an ID is not by itself a seizure, right?
That is a crucial distinction. In a totally consensual encounter, an officer is fully allowed to walk up to you and say, hey, can I see some ID? And as a citizen, you have options. You can say, sure, here it is, show it to them, and put it right back in your pocket.
Or you can just say no thank you and keep walking.
Exactly. Merely asking the question does not trigger the Fourth Amendment.
But that is not what happened with Jordan.
No, Jordan didn't just flash his ID. He physically handed the card over to the officer. The officer took possession of it. And crucially, according to the defense's theory, the officer kept holding it while he proceeded to ask the next series of questions about narcotics and searching the bag.
I really want to dig into why that retention is so critical. Because to a layperson, it might seem like a technicality. Why does a pop holding a 3-inch plastic card suddenly equate to the legal seizure of a human being?
You have to think about the practical, everyday reality of living in modern society. Belton actually quotes the legal reasoning that courts use in these exact types of cases. The courts acknowledge that it is, quote, hard to imagine that any reasonable person in that situation would feel free to leave.
Well, yeah, because practically speaking, I cannot legally drive my car away without that card.
Right. Look at Jordan's immediate situation. He is standing right next to a car. He was just about to get in and be driven away. If the plainclothes officer is holding his driver's license, Jordan is practically immobilized. Unless, of course, he wants to commit a brand new traffic crime by driving away without a valid license.
Which gives the cops a totally valid reason to pull him over 10 seconds later anyway.
Exactly. It's a trap.
But what if he wasn't driving? What if he was just gonna walk home from the bus stop? Does the logic still hold up?
Yes, the courts have said it absolutely still holds up. Think about what a driver's license represents. It is your primary state-issued identity document. Walking away from a police officer while they're actively holding your official ID feels fundamentally wrong. It feels like you are fleeing the scene.
It implies you are abandoning your legal identity just to get away from them.
Exactly. It implies guilt. And frankly, it implies you're leaving something of immense personal value behind. Getting a new license is a huge hassle. No reasonable citizen is going to just shrug, turn their back on an officer holding their ID, and stroll down the street.
It's an amazing analogy. It's like if the cops stopped you and said, hey, can I look at your shoes? And you took them off and handed them over.
That's a great way to put it.
You could technically just walk away barefoot. Nothing is physically stopping you from walking on the pavement. But no reasonable human being is going to do that. They're going to stand there and wait for their shoes back.
Precisely. The courts have basically universally recognized that when an officer holds your license, that card acts as a physical anchor. As long as the officer has it in their possession, the citizen is psychologically and practically tethered to that exact spot on the pavement.
Okay, so let's connect the dots here. If the officer was still physically holding Jordan's license at the exact moment he asked, can I search your bag? Then, according to this doctrine, Jordan was legally seized when he said yes.
That is the argument.
But wait, even if he was seized, don't the cops seize people legally all the time? Why does this specific seizure invalidate the search?
Because of the justification, or rather the total lack of justification, for the seizure. And this is the other massive smoking gun in Belton's breakdown of the case. During the hearings, the officer was asked point blank on the stand, before he consented to the search, did you have probable cause to hold him? Did you have reasonable suspicion that he was committing a crime?
And what did the officer say?
The officer candidly admitted no.
Wow, he just flat out admitted it was a baseless fishing expedition.
He had to. He admitted under oath that without Jordan's voluntary consent to that search, he had absolutely zero legal justification to detain him.
Okay, the logic chain here is brilliant. Let me see if I can trace the whole thing out.
Go for it.
Step 1. The officer takes the license. Step 2. The officer keeps holding the license, which legally transforms the encounter into a seizure.
Great.
Step 3. Because the officer admits he had no reasonable suspicion, that specific seizure is classified as an illegal detention under the Fourth Amendment.
Tracking perfectly.
Step 4. While being illegally detained, Jordan gives consent to search his bag. Step 5. Because the consent happened during a period of illegal detention, the consent is legally tainted. It is the fruit of the poisonous tree.
Exactly.
And step 6. Because the consent is invalid, the 50 grams of cocaine found in the bag must be thrown out of court. Case dismissed.
That is the defense attorney's absolute dream logic chain. It is beautifully constructed.
I am sensing a but here. Because we are analyzing a federal appellate decision right now, which means things clearly didn't get neatly wrapped up in a bow at the trial level. What went wrong with this perfect chain of logic?
What went wrong was the reality of the courtroom, specifically the evidence. Or, to be more accurate, the frustrating lack of evidence regarding one very specific micro moment in time. We basically arrive at what I like to call the he said versus I don't recall problem.
This happened at the suppression hearing, right?
Yes. For the listeners, a suppression hearing is a crucial pre-trial event. It happens before a jury is ever seated. It's where the judge listens to evidence specifically to decide if the police violated the Constitution and whether the drugs can actually be used at the trial.
Right. It's where they argue over the rules of the game before the game starts.
Exactly. So at this hearing, Carl Jordan takes the witness stand, and his testimony is crystal clear. He says, I handed the officer my documents, and he absolutely did not give them back to me until after he had already searched my bag.
Okay, so the defendant is locking in the timeline that perfectly supports the defense theory. The anchor was deployed.
Right. Then it's the police officer's turn to take the stand. Now, strategically, you would usually expect the officer to testify to the exact opposite, right? You would expect him to say, I took the ID, I checked to make sure it was valid, I politely handed it right back to Mr. Jordan, and then after he was free to leave, I casually asked if I could peek in his bag.
Because that testimony would mean the anchor was lifted. It would make the search request fully consensual again.
Exactly. That would be the textbook smart police work answer to save the case.
But I'm guessing that is not what he said.
It is not. And Belton really highlights this moment in the transcript because it is so pivotal. The defense attorney asked the officer on 3 completely separate occasions during the cross-examination whether or not he returned the documents before asking to search.
And what was the officer's answer?
3 separate times, the officer swore under oath that he, quote, simply couldn't remember.
You have got to be kidding me. He couldn't remember. This was a seizure of 50 grams of cocaine. That's a massive career bust. How do you forget the details of how you got it?
I don't recall. It is arguably the most frustrating, impenetrable phrase in all of legal history. The officer could not affirmatively testify that he gave the license back. But, and this is equally important, he also refused to admit that he kept it. He just completely blanked out on that specific 10 seconds of his life.
So the trial judge is sitting there looking at a defendant who swears the cop kept the ID and a cop who just shrugs and says, I have no idea. What do you even do with that?
It created a massive procedural mess, and it became an even bigger problem for the federal appellate court when the case got appealed up to them.
Why is it worse for the appellate court?
Because of how appellate courts function. This is a great nuance that Belton explains. Appellate courts do not call witnesses. They don't hold new trials. They don't weigh who is lying and who is telling the truth. Their only job is to look at the written paper record from the lower trial court and decide if the trial judge made a legal mistake.
I see. They are just reviewing the referee's calls on the field.
Exactly. But in this case, the written record was totally ambiguous. Because the officer's memory was a black hole, the lower court judge had actually failed to make a definitive, factual ruling on whether the ID was returned or not.
So the appellate judges are reading this transcript, trying to decide if the seizure was illegal, but they can't actually do their job because they don't legally know if the seizure even happened in the first place.
You hit the nail on the head. They were completely stuck. They couldn't rule on the law because the facts were missing.
So what was the final outcome here? Did Carl Jordan get to walk out of prison because of a bad memory?
Not immediately, no. The appellate court issued what is called a remand.
Let's explain that term for the non-lawyers listening.
To remand a case simply means to send it back down the ladder. The federal appellate court essentially wrote an opinion telling the lower trial court, hey, you missed a spot. We cannot do our job until you do yours. They sent the whole case back down with extremely specific instructions.
Let me guess. Figure out who was holding the plastic card.
Word for word, basically. They told the trial judge, you need to hold another hearing, evaluate the credibility of the witnesses, and make a hard, factual determination on the record. Did the officer retain the license, or did he give it back?
Wow. That puts an incredible amount of pressure on that lower court judge. I mean, think about the reality of that remanded hearing. The judge has to look at an officer who has already sworn on the record that he has amnesia about this event and somehow magically decide if the guy was holding the card or not.
It creates a genuinely fascinating legal standoff.
Hmm.
And here is the kicker, which gives the defense a huge advantage on remand. The burden of proof in these situations is actually on the government.
Oh, really?
Yes. When a search happens without a warrant, the government bears the burden of proving to the judge that the consent to search was freely and voluntarily given.
Okay, I see where this is going.
If the officer continues to say, "I don't remember if I gave the ID back," how can the prosecutor possibly meet their burden of proof? How can they affirmatively prove Jordan wasn't seized if their only witness can't remember the key fact?
They can't. It's an incredibly steep hill for the government to climb on a remand like that.
It really is.
It just continually blows my mind how these massive, life-altering outcomes, we are talking about years in a federal penitentiary versus going home to sleep in your own bed, they all ultimately rest on such incredibly tiny, mundane procedural details.
It does feel absurd sometimes when you zoom in on it. And I think that is exactly why Anton Belton really wanted the listener to walk away from his analysis with a clear, practical framework for how this doctrine works. He actually summarized this entire complex legal breakdown into 4 key takeaways.
I think we should absolutely run through those to cement all this in our heads. It's a great way to wrap the concepts up.
I agree. Let's do it.
All right, hit me with takeaway number 1.
Takeaway number 1 is the scope of protection. Belton just wants to remind everyone that the Fourth Amendment isn't just about the police kicking down the door of your house. It covers seizures of both your property and your person. The protection literally travels with you wherever you go, even to a public bus stop.
Right, it's a bubble around you.
Okay.
Takeaway number 2.
Modes of seizure. Understanding that you can be legally seized by the government in 2 very different ways. There's physical force, which is the obvious one, the tackle. But then there's the show of authority, the psychological restraint.
Meaning you absolutely do not have to be physically touched to be captured by the police. Exactly.
Okay, takeaway number 3, this is the test, right?
Yeah, takeaway 3 is the free-to-leave metric. This is that objective Mendenhall test we talked about. A show of authority is entirely defined by asking whether a hypothetical reasonable person would feel free to turn and walk away.
And the really weird catch from Hodari D.
Yes, the catch. The show of authority only legally counts if you actually submit to it. If you choose to run away, the rules completely change and you aren't seized until they catch you.
Which brings us to the final one, takeaway number 4. The one that arguably saved Carl Jordan from a decade in prison. The ID doctrine. This is the practical, everyday application of all that dense theory. If a police officer asks for your driver's license, and you hand it to them, if they do not give it back to you after a reasonable amount of time to review it, you are legally seized.
Because a law officially recognizes that holding your primary ID is functionally the exact same thing as holding you.
Yes, it is such a powerful, highly specific rule. And honestly, it is one that every single driver, every traveler, every citizen should just know in the back of their minds.
Absolutely. It completely clarifies the actual power dynamic when you find yourself in one of those tense roadside encounters or getting stopped at a bus station.
Knowledge is power in those moments.
I really want to leave our listeners with a final thought here as we wrap up. We have spent this entire deep dive unpacking the dense legal theory, right? We've talked about the objective tests, the 3 prongs, the appellate review process.
We covered a lot of ground.
But I want you to step back and just visualize that parking lot one more time. Think about the massive what-if hovering over this entire story.
The alternative timeline for Carl Jordan.
Exactly. What if that plainclothes officer had simply remembered his training for 2 seconds? What if he had taken the license, looked at the name, said, "Okay, everything looks good, thanks, Mr. Jordan," handed the piece of plastic back to him, and then immediately said, "By the way, before you go, can I just quickly check your bag?"
If he had just handed it back, the legal anchor would have been completely lifted. At that exact moment, Jordan would have been legally free to walk away. The seizure would be over.
And if Jordan, standing there in that fleeting moment of constitutional freedom, still panicked and said, "Sure, you can search my bag,"
Then the consent would be 100% legally valid. The taint from the earlier stop would be erased. That 50 grams of cocaine would be perfectly admissible evidence in federal court.
and Carl Jordan would almost certainly have been convicted and sent to prison.
Without a doubt.
The entire difference, the literal constitutional boundary line between an airtight federal drug bust and an unconstitutional illegal seizure, was simply the physical location of that 3-inch plastic card for a duration of maybe 10 or 15 seconds.
It is a razor-thin line.
Yeah.
But as Anton Velton's analysis so perfectly demonstrates, the protections of the Fourth Amendment truly live and die on those exact margins.
It definitely makes you look at the wallet sitting in your pocket a little differently.
Certainly does.
Well, a huge thank you to the Law Stash Law Firm and attorney Anton Velton for providing such an incredible, detailed analysis. It is pretty rare to get this kind of granular, trench-level detail on how the justice system actually functions on a Tuesday afternoon.
It is a great reminder for all of us. Know your rights, and
Yeah.
honestly, maybe just try to keep your hands on your own ID whenever possible.
Incredibly sound advice. Thanks for listening to today's deep dive, everyone. We will catch you on the next one.
Stay safe out there.